Thank you.
ഓക്കെ, കോളേജിന്റെ ഏറ്റവും ആദരണീയനായ വലിയ ബഹുമാനപ്പെട്ട മാനേജർ അഗസ്റ്റിൻ പാലക്കപ്പറമ്പിലച്ച, ഇന്ന് ഇവിടെ വിശിഷ്ട അതിഥിയായി എത്തിച്ചേർന്നിരിക്കുന്ന ജിപ്പു ജേക്കബ് സാറെ, ഇന്നത്തെ ഈ പ്രോഗ്രാമിന്റെ ചുമതലയുള്ള മിഥുൻ സാറെ, കോളേജിന്റെ സെൽഫ് ഫിനാൻസ് വിഭാഗങ്ങളുടെ കോഴ്സ് കോർഡിനേറ്ററും ബർസാറുമായ ജോർജ് പുലിയലച്ച, IKC കോർഡിനേറ്റർ ജിലു മിസ്, സുമേഷ് സാറ്, വിശിഷ്ട മറ്റ് അധ്യാപക ശ്രേഷ്ഠരെ, പ്രിയ വിദ്യാർത്ഥിനികളെ, ഇന്റലക്ച്വൽ പ്രോപ്പർട്ടി റൈറ്റ്, ഭൗതിക സ്വത്തവകാശവുമായി ബന്ധപ്പെടുത്തിയുള്ള വളരെ പ്രസക്തമായ ഒരു വിഷയമാണ് ഇന്ന് ഈ വെബിനാറിലൂടെ കൈകാര്യം ചെയ്യപ്പെടുന്നത്. അതിന് എത്തിച്ചേർന്നിരിക്കുന്ന വിശിഷ്ട അതിഥിയും നമ്മൾക്ക് ഏറ്റവും സന്തോഷം പകരുന്ന ഒരു വ്യക്തിത്വത്തിന്റെ ഉടമയും കൂടെയാണ്. ഞാൻ മിഥുൻ സാറുമായി സംസാരിച്ചപ്പോഴേ നമ്മൾക്ക് നാട്ടുകാർക്ക് ഏറ്റവും പ്രയോജനം ചെയ്യപ്പെടുന്ന ഒരു ഉപകരണം കണ്ടുപിടിച്ച വ്യക്തിത്വമാണെന്ന് പറഞ്ഞപ്പോൾ സത്യം പറഞ്ഞാൽ സന്തോഷം തോന്നി. ഏറ്റവും ബുദ്ധിമുട്ടോടെയുടെ ഒരു പ്രവർത്തനമായി ഇപ്പൊ കണക്കാക്കുന്ന തെങ്ങ് കയറ്റത്തിന് സാധാരണക്കാർക്ക് ഉപകാരം ചെയ്യുന്ന ഒരു ഉപകരണം കണ്ടുപിടിച്ച് അവർക്ക് സഹായം ചെയ്തു കൊടുത്ത വ്യക്തിത്വമാണ് ജിബു സാർ എന്ന് പറയുമ്പോൾ സന്തോഷം രേഖപ്പെടുത്തുന്നു. ഈ കലാലയം അദ്ദേഹത്തിന്റെ വാക്കിന് വേണ്ടി കാതോർക്കുന്നു. ഈ കലാലയത്തിലെ എല്ലാവർക്കും വേണ്ടി വളരെ സ്നേഹത്തോടെ ആദരവോടെ അദ്ദേഹത്തെ ഈ ചടങ്ങിലേക്ക് സ്വാഗതം ചെയ്യുന്നു. അതിനോടൊപ്പം IQSയുടെ നേതൃത്വത്തിൽ വ്യത്യസ്തമായ രീതിയിലുള്ള പ്രോഗ്രാമുകൾ ഈ കലാലയത്തിൽ സംഘടിപ്പിക്കപ്പെടുന്നു. അതിന് നേതൃത്വം വഹിക്കുന്ന എല്ലാവർക്കും പ്രത്യേകിച്ചും അഭിനന്ദനം രേഖപ്പെടുത്തിക്കൊണ്ടും ആശംസ നേർന്നുകൊണ്ട് നിർത്തട്ടെ. നന്ദി.
നമ്മുടെ കോളേജിന്റെ പ്രിയങ്കരനായ പ്രിൻസിപ്പൽ ഡോക്ടർ റെജിവർഗീസ് മേക്കാടൻ സാറെ, പ്രിയമുള്ള ജോർജ് പുല്ലുകാലച്ച, പ്രിയമുള്ള മിഥുൻ സാറെ, ഇന്ന് നമുക്ക് വിശിഷ്ടാതിഥിയായി അനുഭവങ്ങൾ പങ്കുവെച്ച് നമ്മോട് എത്തിയിരിക്കുന്ന പ്രിയമുള്ള ഡോക്ടർ ജിപ്പു ജേക്കബ് സാറെ, വാത്സല്യമുള്ള വിദ്യാർത്ഥികളെ, പ്രിയമുള്ള അധ്യാപകരെ, നമ്മുടെ കോളേജ് നിരന്തരമായി നമ്മുടെ വിദ്യാർത്ഥികളുടെ മാനസിക വികാസം, അവരുടെ ബൗദ്ധിക വികാസം, അതിനെല്ലാം വേണ്ടി നടത്തിക്കൊണ്ടിരിക്കുന്ന എല്ലാ പ്രോഗ്രാമുകളും ഓരോ ദിവസം ചെല്ലുന്തോറും ഓരോ പ്രോഗ്രാമും വൈവിധ്യവും കൊണ്ടും അതിന്റെ മേന്മ കൊണ്ടും ഒത്തിരിയേറെ സഹായകരമാണ്. ഇന്ന് ഈ പ്രോഗ്രാമിന്റെ വലിയൊരു പ്രത്യേകത, ഇന്റലക്ച്വൽ പ്രോപ്പർട്ടി റൈറ്റിനെ പറ്റി നമ്മുടെ കുഞ്ഞുങ്ങൾക്കൊരു അവയർനെസ് കിട്ടുന്നു. നമ്മൾ പാഠപുസ്തകത്തിൽ നിന്ന് കുറെ കാര്യങ്ങൾ പഠിച്ച് മാർക്ക് വാങ്ങിയ ഒരു സർട്ടിഫിക്കറ്റുമായി നമ്മൾ ഒരു ജോലിയിലേക്കോ അല്ലെങ്കിൽ ജോലി ഇല്ലാതെയോ, അതിനേക്കാൾ കൂടുതൽ നമ്മുടെ സമൂഹം വലിയൊരു കാർഷിക സംസ്കാരത്തിന്റെ സമൂഹമാണ്. സാധാരണക്കാരായ ആളുകൾക്ക് പ്രയോജനപ്രദമായ കാര്യങ്ങൾ നമ്മുടെ സമൂഹത്തിന് കോൺട്രിബ്യൂട്ട് ചെയ്യാൻ സാധിക്കണം. എൻ്റെ മനസ്സിൽ പെട്ടെന്ന് ഓർത്ത ഒരു കാര്യം, ഞാനൊക്കെ പഠിക്കുന്ന അവസരത്തില് വലിയ ലേഖനം എഴുതിയ ഒരാള് ചോദിച്ച ഒരു ചോദ്യം ഞാൻ ഓർക്കുകയാണ്. അദ്ദേഹം പറയാണ്, നമ്മുടെ നാട്ടിൽ അന്ന് കാളവണ്ടി എന്ന് പറയുന്ന ഒരു കൃഷിക്കാരൻ വാഹനമായിട്ട് സാധനങ്ങൾ കൊണ്ടുപോകാൻ ഉപയോഗിക്കുന്ന, അദ്ദേഹം പറഞ്ഞു, കേരളത്തിലെയോ ഇന്ത്യയിലെയോ സർവകലാശാലകളിൽ ഒരിടത്തും ആ ചക്രം അല്പം കൂടി സ്പീഡിൽ കറങ്ങാനുള്ള എന്തെങ്കിലും ഒരു മെഷീൻ ഒന്ന് കണ്ടുപിടിക്കാൻ അതിന് സാധിച്ചില്ലെങ്കിൽ പിന്നെ എന്തിനാണ് ഈ സർവകലാശാലകൾ എന്ന് അദ്ദേഹം ചോദിക്കുന്നുണ്ട്. സാധാരണക്കാരന് പ്രയോജനമുള്ള എന്തെങ്കിലും വരുന്നില്ല എങ്കിൽ കുറെ സർട്ടിഫിക്കറ്റുകൾ കൊടുക്കാൻ മാത്രമാണെങ്കിൽ, അതുപോലെ മറുവശം കുട്ടികളിൽ നിന്നും 100 രൂപയുടെ നടക്കേണ്ട കാര്യങ്ങൾ 1000 രൂപ കുട്ടികളിൽ നിന്നും വാങ്ങിക്കാനും, അത് വാങ്ങിച്ച് ജോലിക്കാരായിട്ടിരിക്കുന്നവർക്ക് ശമ്പളം വീതിച്ചു കൊടുക്കാനും, അങ്ങനെ ഈ കുഞ്ഞുങ്ങളെ ആദ്യം തന്നെ അവരുടെ മനസ്സിലൊരു അനീതി സംഭവിച്ചെന്ന് തോന്നത്തക്ക തരത്തിലുള്ള അമിതമായ ഫീസ് ഭാരങ്ങൾ വാങ്ങിക്കുന്ന പ്രസ്ഥാനങ്ങളൊക്കെ ആയിട്ട് എന്തിന് നമ്മുടെ സർവകലാശാലയിൽ നിൽക്കുന്നു എന്നൊക്കെയുള്ള ചോദ്യങ്ങൾ നമ്മുടെ മനസ്സിൽ വരും. അപ്പൊ തീർച്ചയായിട്ടും ഇതുപോലെ ജീവിതത്തോട് ബന്ധപ്പെടുത്താൻ കഴിയുന്ന അറിവുകൾ അത് വളരെ പ്രധാനപ്പെട്ടതാണ്. അങ്ങനെ ഒരു വലിയ അറിവുമായിട്ടാണ് പ്രിയമുള്ള ജിപ്പു സാർ ഇന്ന് നമ്മളെ അഭിസംബോധന ചെയ്യുന്നത്. സാറിനെ ഞാൻ പ്രത്യേകമായിട്ട് സ്ഥാപനത്തിന്റെ പേരിലുള്ള വലിയ സന്തോഷം അറിയിക്കുന്നു. ഈ യോഗത്തിന് എല്ലാവിധ നന്മകളും നേരുന്നു. നന്ദി.
ഗുഡ് മോർണിംഗ്. ഏറ്റവും ആദരണീയനായ കോളേജിന്റെ മാനേജർ വെരി റവറൻഡ് ഡോക്ടർ അഗസ്റ്റിൻ പാലിക്കപ്പറമ്പിലച്ച്, കോളേജ് പ്രിൻസിപ്പൽ ആദരണീയനായ ഡോക്ടർ റെജി വർഗീസ് മെക്കാടൻ സാറെ, ഇന്നത്തെ നമ്മുടെ വിശിഷ്ട അതിഥിയും ഇന്ന് നമ്മോട് സംസാരിക്കുകയും ചെയ്യുന്ന ഡോക്ടർ ജിപ്പു ജേക്കബ് സാറെ, മിഥുൻ സാർ, ഐക്യൂസി കോർഡിനേറ്റേഴ്സ്, ആദരണീയരായ വിദ്യാർത്ഥികളെ, സിഗ്നിഫിക്കൻസ് ഓഫ് ഇന്റലക്ച്വൽ പ്രോപ്പർട്ടി റൈറ്റ് ഇൻ അക്കാഡമിയ എന്ന വിഷയത്തിലെ വെബിനാർ ഉടനെ തന്നെ ആരംഭിക്കുകയാണ്. വളരെ തുടർച്ചയായി കുട്ടികൾക്ക് ഉപകാരപ്രദമായ രീതിയിൽ വ്യത്യസ്തമായ പരിപാടികൾ, വെബിനാറുകൾ ഇതിനോടകം തന്നെ ഈ മിഥുൻ സാറിന്റെ നേതൃത്വത്തിൽ ഇവിടെ സംഘടിപ്പിക്കപ്പെട്ട് കഴിഞ്ഞു. കോമേഴ്സ് ഡിപ്പാർട്ട്മെന്റിൽ നിന്നും സാറിനെയും സാറിന്റെ സഹപ്രവർത്തകരെയും പ്രത്യേകം അഭിനന്ദിക്കാൻ ഈ അവസരം ഞാൻ വിനിയോഗിക്കുകയാണ്. കൂടാതെ കുട്ടികള് ഏതാണ്ട് 70ഓളം കുട്ടികള് ഇതില് ഇപ്പോൾ ഗൂഗിൾ പ്ലാറ്റ്ഫോമില് പങ്കാളികളാവുന്നുണ്ട്. ഇതിൽ അധികം കുട്ടികള് യൂട്യൂബിലൂടെയും പങ്കെടുക്കുന്നുണ്ട് എന്ന് വിശ്വസിക്കുകയാണ്. ഈ ഇന്റലക്ച്വൽ പ്രോപ്പർട്ടി റൈറ്റിനെ കുറിച്ചുള്ള ക്ലാസ് കുട്ടികൾക്ക് ഏവർക്കും അവരുടെ മുന്നോട്ടുള്ള വളർച്ചയിലും സമൂഹത്തിന്റെ പുരോഗതിയിലും കാരണമാകട്ടെ എന്ന് ഞാൻ ആശംസിക്കുന്നു. അതുപോലെ തന്നെ കാഞ്ഞിരപ്പള്ളി അമൽജ്യോതി എഞ്ചിനീയറിംഗ് കോളേജിലെ അഡ്ജങ്ക്ട് ഫാക്കൽറ്റി ഡോക്ടർ ജിപ്പു ജേക്കബ് സാർ ഇപ്പോൾ നമ്മളോട് കൂടെ ഉണ്ട്. സാറിന്റെ സാന്നിധ്യം ഞങ്ങൾക്ക് ഏറെ വിലപ്പെട്ടതാണ്. സാർ ഇന്ന് ഈ ഓൺലൈൻ പ്ലാറ്റ്ഫോമിലൂടെ ഞങ്ങളോട് സംവദിക്കുന്നതിൽ ഞങ്ങൾക്ക് അതിയായ സന്തോഷമുണ്ട്. സാറിനെ സ്നേഹത്തോടെ സ്വാഗതം ചെയ്യുന്നു. എല്ലാ നന്മകളും നേർന്നുകൊണ്ട് എന്റെ വാക്കുകൾ അവസാനിപ്പിക്കുന്നു.
Yeah. At the outset, let me congratulate the authorities, the administration of St. George's College, Adivitra, for having selected such a topic of relevance. They are very much concerned about making innovations and bettering the standard of living of every human being in this world. If this is to be achieved, there is a necessity for doing innovations, writing stories, writing poems, and then protecting our rights. Okay? And secondly, I express my gratitude to the authorities of St. George's College, and more particularly the principal, the manager, the bursar, and also Professor Mithun, for having invited me and given me an opportunity to make this presentation. So let me go directly into the topic. I'll be talking about intellectual property rights, an overview of that and its relevance in the academia. Going to the next slide, you can read here, it's time for Indians to take up their rightful place on the global arena of creativity and innovation, not only as creators and innovators, but also as owners of intellectual property. We look at the last line, which says, but also as owners of IP. And that is where the relevance exists for this particular topic. ഇത് നന്നായിട്ട് ചെയ്തെങ്കിൽ മാത്രമേ നമ്മുടെ ഒരു രാജ്യത്തിന് പ്രോഗ്രസ് ചെയ്യാൻ സാധിക്കുകയുള്ളൂ. ആൻഡ് പലർക്കും സംശയമുണ്ട് ഇത് നമ്മുടെ ഒരു ആർട്സ് ആൻഡ് സയൻസുകാർക്ക് അല്ലെങ്കിൽ കൊമേഴ്സുകാർക്ക് എന്താണ് ഇങ്ങനെയുള്ള ഒരു ഇതുകൊണ്ടുള്ള ബെനിഫിറ്റ് എന്ന്, particularly regarding innovations. I'll take an example. Just see this. I would say this is one of the best equipment, a device.
Sir, excuse me, sir. Are you presenting something?
Yeah.
Yeah, it is not visible, sir.
It's not visible? Okay. Is it visible now? Now is it visible?
Sorry, you are not in the presenting mode and presentation mode. Not in presentation mode, sir.
Let me check that. Is it visible now?
No, sir. Can you do person now? Can you?
Is it visible?
No, not. Yeah, it's coming. Yeah, yes, sir.
It has come?
Yeah, yes, sir.
Okay. So the particular topic is on intellectual property rights and overview. What is the importance of this intellectual property rights? I'll go to the next slide, which says, it is time for Indians to take up their rightful place on the global arena of creativity and innovation, not only as creators and innovators, but also as owners of IP. I draw your attention to the last line, which says, but also as owners of IP. There are many instances where people have made innovations, they have created artwork, but they have not been owning it. Now we are living in a world which is very competitive in nature. We are competing with our fellow countrymen. We are competing with others in the other countries. And in such a situation, if we want to win, and we have to protect our rights, and that can be done by owning intellectual property. Very often a question arises or is asked whether what can be done by students or those who have pursued career in arts, science, technology, medicine, etc. There is a room for everyone. I'll draw an example. See this equipment, where this particular lady is even climbing the coconut palm with that equipment. She is wearing the sari. Without this, it is almost impossible for any lady to go up a coconut palm wearing a sari. There are many ladies who climb up the coconut trees. But with a sari on, it's very difficult. Now, this particular invention, as you can see the caption, coconut climbing machine by an illiterate farmer. Mind it, this is by an illiterate farmer. How could he do that? He didn't go to school. Must be that he studied up to third standard or so. But his ingenuity, creativity led to this particular tool. I would say this is one of the best tools invented in Kerala for the farmers and by a farmer who is illiterate. The person who invented it is Mr. St.George, is no more. He is the person at the age of around 60, he invented this tool. He didn't know what is science, he didn't know what is technology, or what is engineering. Still he managed to come up with such a marvelous equipment. This tool is in use not only in India, even in outside country, other countries also, like Sri Lanka, Malaysia and so on. And if such an equipment could come out or could be created by an illiterate farmer, why not those studying in colleges and schools and pursuing subjects like or disciplines like arts, science, commerce, etc. So there is a great responsibility upon you to be creators, be innovators, and also as owners of intellectual property rights. When we consider intellectual property rights, it is better to make a quick look at the GDP. This is one of the primary indicators used to gauge the health of a country. And what are the key ingredients in considering gross domestic product? First one is raw materials. Second one is human resources. Third, technology and innovations. India is rich in raw materials. India is rich in human resources. But what about technology and innovations? We are lagging behind, but we are slowly catching up. So there is a necessity to accelerate the process of creating technology and innovations and also making use of that. When we consider this, we consider what is wealth. That is where most of the things have to be protected. Wealth is classified into two groups. The first one is tangible property. Second one is intangible property. Under the tangible property, this is a property perceptible by touch. We can feel it. One, and that is also classified into two groups. Movable property, such as the stapler which is shown here, a pen and so on. And immovable property like a building. So somebody would be owning a movable property, somebody would be owning an immobile property, and someone can dispossess it. And another second class is intangible property, not having any physical presence, that is created in the intellect and then transferred as a creation. And that is basically known as intellectual property. And what is basically intellectual property? Intellectual property is nothing but the creations of human intellect. It is a product of mind. And it comes from an idea and it is converted to a creation. So it's a combination of an idea and a creation. Just by having an idea is not enough. It has to be brought into existence through creation. So when these two are combined, we get something which can be used for bettering our standard of living. A person possessing a property can be dispossessed. So that can be illegal possession as well. There is legal possession. You can transfer the right to someone. You are owning a property, you want to sell it, and you go to the registrar's office, you transfer the property, which is the other person is legally possessing it. But there is illegal possession of more. You can see that a thief is stealing the money from the lady's handbag. That is illegal possession of the property. And in the case of the immobile property, which a person, a land or a building, it is forceful possession. It is illegal possession. And here is the fellow has been checked out of the building he was owning earlier. And there too it is illegal possession. And in the case of the intellectual property, see someone has made an idea, he is converting it into an art form, and this fellow is simply copying it. This is nothing but plagiarization. So that is, in the case of intellectual property, that will be termed as plagiarism. And therefore, here, what are the types of property and how it can be illegally, or what are the terms used for illegally possessing it? Mobile property, when it is illegally possessed by someone, it is known as stealing. If it is immobile property, it is occupation. And if it is intellectual property, it is known as infringement. And what is infringement? The action of breaking the terms of a law, agreement, etc., which is a violation. Copyright infringement and infringement of the trademark and so on. And there are machinery for controlling it, illegal possession. It can be the police is running after the thief, so the state is taking care of that. The countries, and there are other types like the court, where you can get legal remedies, and that can, and the apex court in India, as you know, is the Supreme Court of India. So either the police or the courts take care of your rights. So here, a person is running away with an intellectual property, so you have got to protect your intellectual property. Now it's time to see what are all the different types of intellectual property in India. Every country has its own arena for this, and as far as India is concerned, we have 7 regions or regimes in which intellectual property is taken care of. As you can see, the first one is copyright. Every one of you must be familiar with copyright. You must have also heard about trademark. You also heard about design, patent, layout design of integrated circuit, geographical indication, and trade secret. These are the 7 areas or disciplines where intellectual property rights are protected in India. And what are the advantages in protecting intellectual property? You transfer the right to another person for manufacturing it or publishing a book and so on. Reserve the right for future government protection. Only if it is protected that if any infringement occurs, you can take to the government for its protection. That can be done only if it is properly protected. Ensure proper distribution of intellectual property. Potential financial gain, you can gain money from that. Recognition of the efforts of innovators, government and others are recognizing it. Your invention, your artwork and so on. Gain prestige for the institution, certainly. Benefiting the society, ultimately, it's all becomes as a benefit to the society. Very often you see boards such as this is a private property and no trespassing, keep out. So it is somebody's property, he is legally possessing it, and trespassing through that is illegal. You have to get his permission for that. So it's very important that we have to know our rights. So here, what I am going to present is basically on knowing your rights regarding intellectual property, that is intangible property, which cannot be felt, right? That means the creation of your mind. First, we will consider the copyright in India. So this is a grammar book, my blue book of grammar, written by one of the professors in my college here at Amurjodi College of Engineering, Kanyarapalli. If you look at its the backside of or the reverse side of the cover page, you can see here the letter C encircled against which is written Shape Publishing House. All rights are reserved. No part of this publication may be reproduced, stored in, or introduced into a retrieval system transmitted in any form by any means without prior written permission of the publisher. So as far as this book is concerned, the author has obtained a copyright. It has been registered with the Government of India, and that right he has transferred to the Shape Publishing House. So they are now owning it. And therefore, whatever they are doing, it's not an infringement. But if anyone else is doing that, it becomes an infringement. You can see a photograph, which is also against that photograph. Under that, it is written copyright. That means this is also a copyrighted item. There are different symbols used to represent copyright. As you can see here, one is simply a circle within which is written the letter C, or copyright 2017, or all rights reserved 2017 copyright, and so on. So these are some of the forms in which it is communicated to others that that particular thing is a copyrighted item. And see here, what are the copyrights? And it is applying to artistic work, literary work, dramatic work, musical work, cinematographic film, sound recording, and software. So these are the areas in which copyright exists. It vests in the original work only, in whatever form it may be, literary, artistic, etc. So it's not vesting in copies. It has got to be original. Registration of copyright in India is not mandatory, but useful in courts where civil and or criminal proceedings is needed. Sometimes there will be an infringement. You may have to get a redressal from the court of law. So when you go to the court of law, they would ask whether the copyright is registered. And generally legal remedies can be made use of. So it's important to have it registered. Once it is registered, if there is an infringement, you are safe, and go to the court and you can get a remedy for that. And it gives exclusive right granted to the owner of a literary, artistic, or a scientific work. The right to copy or reproduce the work in which the copyright exists. So you get the right to copy, reproduce the work in which the copyright exists. Exclusive right to do or authorized to do certain acts. So my professor, the professor in my college, after writing that book on grammar, he has transferred the right, he has authorized others to do certain acts. Shared publishers has been permitted or authorized to publish it, to market it. So certain exclusive rights have been granted to such people. And copyright law offers protection to the expression of thought based on some idea and not for the idea as such. So it has to be expressional. The thought has got to be expressed based on some idea and not for the idea as such. If you are not converted to a book form, naturally you won't get it. If it has not been converted to a film, you will not get that. It offers a bundle of exclusive rights to the owner, right of reproduction, right for adaptation and translation, right of distribution, right of public performance, and right of broadcasting. And where to apply for copyright and its fees. You have to apply to the Registrar of Copyright Office in Delhi, and it has got a different fee structure for that. If it is literary, dramatic, musical, or artistic work, you have to apply in Form 14, given by the Registrar of Copyrights or the Indian Patent Office, and the fees to be paid is rupees 500. If it is a cinematographic film, the fee is 5,000. If it is a sound recording, it is 2,000. So accordingly, you find that depending upon the class of work, you need to pay different, but form is the same. So this is the symbol of the Copyright Office or the trademark of the Copyright Office, and you can see it, this is the address in which one has got to apply. Now a question arises whether renewal is required. In the case of copyright, renewal is not at all required, and up to what time limit you can avail of it. Up to 60 years beyond the death of father. So there are two conditions here. One, 60 years. When? From when onwards? Beyond the death of father. So throughout the period of life of the author plus another 60 years. That will be the time up to which the copyright is granted to the person. And there are also certain variations. Author's life plus 60 years for all literary, artistic, and musical work. But if it is a photographic work, it is only 60 years. And so also for cinematographic films, for government work, and for sound recordings. So it's only 60 years. The other one, literary, artistic, and musical work, it is author's life plus 60 years. And what are the related rights or neighboring rights? That is, rights of persons or organization who add substantial creative skill, technical skill, or organizational skill. Say one person writes a poem, a song. Lyrics is written by someone. Only if that person doesn't have a good tune, naturally if he is singing it, nobody is going to listen to it. But if Yeshudas is singing it, or if Chitra is singing it, then it adds much creative skill to that. And so also somebody writes a story for a film, and there is a technical skill awarded to that. Organizational skill. So in the process of bringing a work available to the public, it will have a creative skill, a technical skill, or organizational skill. And what are the related rights? That is protection to performing artists, producers of phonograms, broadcasting organizations. So if Doordarshan is a broadcasting organization, so it's adding certain organizational value to it. Producers of phonograms, there's a technical skill involved in it. Performing artists, is adding creative skill to that. And from unauthorized, so it grants protection to performing artists, producers, broadcasting organizations from unauthorized exploitation of their rights. It is protection from unauthorized exploitation of their rights that resulted from financial resources, organizational resources, and technical skills which they add to the copyright protected work. And you can see here. So here, broadcasting. So when they are broadcasting, everyone is able to hear. A sound recorded system. Here, she is singing the song. So everyone is adding, so what are the rights associated with them are related rights or neighboring rights. Now we go on to the second one, that is a trademark in India. All of you must be familiar with this. This is a very famous one. I can see just at the end of the word of Bata, you can see there is a small circle in which is written letter R, which indicate that this is a registered trademark. And you can see the Audi car and then also Starbucks coffee. So these are some of the famous trademarks. And what is a trademark? Or sometimes it also refers to service mark. A mark capable of being represented graphically and capable of distinguishing the goods or services of one person from those of others. So it is a mark capable of being represented graphically. So all these are represented graphically and capable of distinguishing the goods or services of one person from those of others. May include shape of goods, their packaging, and combination of colors. You can see here a trademark with a letter R by the side of that, which indicates that this is a registered trademark. It is registered with the Government of India. And it could be a service mark. I'll come to service mark later. The registered trademark logo. This is how the registered trademark logo is granted. And a mark includes a device, a brand, heading, label, ticket, name, signature, word, letter, numeral, shape of goods, packaging, or any combination thereof. This is how it can be represented. You can see here, a trademark can be a word mark such as Ford, Sony. So this is a word, Annapurna. Or it could be devices of figurative elements, that is logos. Now St. George's College, Adivithra is having a logo, an emblem. An abbreviation such as IBM. So it's an abbreviation, a number, a letter, a slogan, and sometimes even a smell is used. You can see here 8888. And here it is a device as it is shown. And General Electricals, this is another one. And these are some of the world famous trademarks. And see here, this is that of the Starbucks. It has undergone changes from period to period. You can see here in 1971, it had the first one. They changed it in 1977, which is represented here as the second item. And they changed again to 1992 to the third one. And lastly, they changed it in 2011 to the fourth one. So the trademark has undergone changes. So it's not necessary that one should stick on with the same trademark, depending upon the conditions and so on, and you can change it as well. But it has got to be registered every time. And what are some of the criteria this act is it must not be descriptive. Don't write paragraphs. Must not be deceptively similar to known or well-known marks or generic. Avoid using geographical indications, deities, national leaders, heroes, symbols, laudatory words, and so on. So it must not be descriptive. It must not be deceptively similar to well-known trademarks. Now see here. All of you can see that this is the trademark of Godrej. So it is imprinted on the front cover of the refrigerator Godrej. This is another one. This is a trademark written on the on an almirah, which is in my room. I didn't purchase it. Someone else had purchased it. When I occupied the room, this particular almirah was there. And you see, it appears to be that of Godrej. But you see the difference here. The first one is the official registered trademark of Godrej. And look at the second one, that on the almirah. The first one is Godrej is Godrej. But here they have deceptively introduced an R between O and D. So it is Godrej. Godrej. and they are deceptively similar. So Godrej could of course go for a litigation and have this particular fellow or the person who is using it, because they are deceptively similar. So this is just to confuse people. I don't know the person who went to purchased it thinking that it is Godrej. And some of the trademarks is capable of distinguishing services. I am going to the service marks. Marks capable of distinguishing the services refers to education, which is a service to the community. Insurance is a service to the community. Banking is a service to the community. So also hotels, laundry, transport, research laboratories. Now all of you must be familiar with the first one, which is the logo or the emblem of St.George's College at Vitra. And the second one on the right is that of the Indian Railways. You must be very familiar with this. And so also that of the Council of Scientific and Industrial Research. So that it refers to the last one, which is a research laboratory, and railways applies to the transport, and St. George at Vitra concerns with the service, that is education. And these are some of the trademarks you must be familiar with. The first one is on Chartered Accountants, Association of Chartered Accountants. And the second one is that of the Indian Medical Association. These are generally known as collective marks because it is owned by an association whose members use them to identify themselves with a level of quality and other requirements set by the association. Very often you will hear that somebody is acting against the requirements, and they will be checked out of the association. So once a person is a member of an association, he will have to maintain certain ethics. So this is concerning collective marks. Associations representing accountants, engineers, architects, and so on. So all these are known as collective marks. Trademarks, you have to do a trademark search and find out whether something similar to what you intend to use as a trademark is already adopted by someone else. So you can check that with the records available with the trademark office, and you can see it in the trademark journals or with the government. The marks either registered or pending registration, or can also be verified from this. And this is the trademark journal. So we can refer the trademark journal and find out whether someone else is already using the trademark which you intend to use. And you have to register it with the Controller General of Patents, Designs and Trademarks. This particular controller is dealing with three things of intellectual property: patents, designs and trademarks. So trademarks is coming under the Controller General of Patents, Designs and Trademarks. It has 5 offices like Mumbai, Ahmedabad, Kolkata, New Delhi and Chennai. So when we are applying, we have to apply to the Chennai office from Kerala. And different, this is the address where you got to apply, and the registration, and then what are the forms and what are the fees. Textile trademark, it is 4,000, collective trademarks is 10,000, and renewal it is 5,000. And it has got to be registered here. You might remember that for the books, if a copyright is there, it is 60 years beyond the life of the author. You don't get that sort of a term here. The registered trademark to be renewed after every 10 years. So it is to be registered after every 10 years, and it is unlimited. So this is the one which is having unlimited period, as long as renewed as per law. If you are not renewing it, naturally it will cease. And different types of trademarks. One can be product trademarks. You have a product that it may have a trademark like Maggie. That shows that it is a product trademark. A service trademark, Axis Bank, DHL Express, etc. And that is represented because they are giving service to the community. Certification trademark, they check the standard of the product like ACMARC, Woolmark, ISI, etc. These are all certification trademarks. Collective trademarks like doctors, CA, handicraft, etc. Then unrelated trademarks, Apple. You know, basically Apple is a fruit, but you are using it against a computer. So Apple is one, BlackBerry, Paperboat, etc. So even though they are some of the things, but directly it is not related to the particular thing. Well-known trademark like Pepsi, Samsung, etc. They are well-known trademarks. And what should I use? Trademark or registered? So it has to be registered trademark. Here you can see the second one, V-Guard. On the right top, you can see it's written letter R and it is encircled, which is an indication that this is a trademark registered with the government of India. If R is not there, it indicates that it is a trademark, but it's not a registered one. Now we move on to the third category item in the intellectual property, which is known as the design. Take this example of this bottle. It has certain artistic work on that. You can see some wavy lines are there, some figures of people here, and so on. And it is represented from 5 views, from 5 directions. Photos are taken. One is taken from the top, and second one taken from the bottom. And it is having certain figures and patterns on that. That is the design. And design can be registered design. Registered design example, car body shapes are good examples of registered design. Manufacturers want to stop other companies copying successfully styled cars, even if the technology inside the car is too similar to the previous models to be able to patent them. Distinctive features such as radiator grills can be protected as well as the overall body shape. And design means only the features of shape, configuration, pattern, ornament, composition of lines or colors applied to any article whether in 2 or 3 dimensional or both forms. So it refers to mainly features of shape, etc. And it has to be created by some industrial process, whether by manual, mechanical, chemical, separately or combined, which in the finished article appeal to the eye. That is important. In the finished article, when the pattern is given or the design is given, how it appeals to the eye, that is important. Judge this only by the eye. It doesn't matter what function it serves. It's not applicable in the design. In the design, how it appeals to your eyes. That is why we have different types, different shapes for the pens, different shapes for the cars, for the vessels and so on, because it is appealing to the eye. First you see what is the color, how the lines are given. So that is appealing to the eye. So you are checking whether something is appealing to your eye. If it is appealing to the eye and somebody is trying to copy that particular design, naturally you can get a remedy for that. And you are got to apply with the controller of patents, designs, and trademark. You've got to apply here. And registration of design and its renewal. It also has got to be renewed. And it has to be applied in Form 1, which is a natural person. I am a natural person. But when it is said, the registrar of a university or the controller of a university, now that institution is could be a small entity or a big entity, large entity. Accordingly, if it is a natural person and if you are registering the design, you need to pay 1,000. If it's a small entity like a small college or a small department, it is 2,000. A large entity like a big university and so on, you have to pay 4,000. Renewal is again 2,000, 4,000 and 8,000. This is how the fees are fixed. And renewal designed to be renewed after every 10 years from the date of application, but it has a limited period such as 15 years. And we have seen that in the case of the trademark, it is unlimited, but it has got to be renewed after every 10 years, it has got to be renewed. And copyrights, either 60 years or life of the author plus 60 years. And here in this case, this term is only up to 15 years. Thereafter, anyone can use the design, and but it has got to be renewed at the end of 10 years. Next, we move on to a very important one, which is known as patent in India. The patent in India is coming under intellectual property rights. It is governed by the Patents Act 1970. It has undergone too many amendments. And what is a patent? According to the Patent Act 1970, patent is a statutory right, so it grants a statutory right for an invention. So it's for an invention. It's not for a design. It's not for a literary work. It is for an invention. It is granted for a limited period only to the patentee by the government. So this particular statutory right is granted by the government to the patentee for a limited period and for in exchange of full disclosure of his invention. You are going to define, you are going to give the details or the specifications or the inventions which you have made. So it has to be disclosed before the Registrar of Patents. And patents rights are for excluding others from making it. It's for using it, selling it, and importing the patented product or process for producing that product for the purpose without his consent. So this right, patent right is for excluding others from what? Others cannot make it without the consent of the patentee. Others cannot use it without the consent of the patentee. Now here, you will have a doubt whether I buy something from the market and then I use it, so whether it is an infringement. If it is a product manufactured by a concern having the patent right, then it is permitted. I don't have to separately take a patent code. But if I use an item purchased from an illegal manufacturer who has infringed the patent right, then I am also liable for penalty. So, but if it is a case of something which somebody has patented, and if someone is using it, made by a person for whom or to whom the rights have been transferred, it is not an infringement. So also selling also cannot be done. Very often we hear about the court cases regarding the selling of product through an infringement. And importing also for the same purposes, that is also not permitted. What can be patented? An invention of either a product or a process which is new, involving an inventive step and capable of being industrially produced. However, it must not fall into the categories of invention that are not patentable under, say, some inventions related to atomic energy, defense. They are not patentable. So, there are certain items which are classified as non-patentable items. So one has to see, particularly in areas referring to the atomic energy, defense, etc., you have to see whether it is falling under the category where it is non-patentable. Otherwise, you can patent it. And what is an invention? It is a creation or devising of something new or original. It has got to be new. You see here, what are the criteria of patentability? Should be novel, as on the date of application. As on the date of application, filed with the patent office, as on that date, that is the date on which it is filed with and the time at which it is filed. Thereafter, novelty is no matter. But till that time, it has got to be novel. That means it should not be known to many people. Should have an inventive step. I will explain that. It must be non-obvious. Should be capable of industrial production. Should not fall within the provisions of the, as I mentioned, atomic energy and so on. Here you can see there is a, in the first figure, there is a straw. This is a straight straw. He is drinking water or some juice liquid from that glass. And see here where his face is located. His face is above the glass. And see the second figure where they are showing the straw bent at different angles. So it has a bellow in between from where it can be bent in any direction. And see the third figure. It's a bent straw. And see his face. The face is ornament in the natural position. So this first figure, the person has got to move his head or face in such a manner that his face comes over the glass. And what a simple innovation it is. Simply by providing a bellow in between or somewhere in the middle of the straw, the straight straw, you can bend it in any direction, it at any angle, according to your requirement. And it improved the convenience. So it is now more beneficial to use. And this is a simple one. Till that time, the bellow was introduced, everyone was using the straight straw. So this is a very novel one. That is the inventive step. What is the inventive step? That is the incorporation of or building a bellow into the straw. And that is the inventive step. And see here, a paperclip. This is the first invention. And this is the second one. You can see there is some difference between the two. And here, it has certain drawbacks. That is why people went for the second one. And the case of the first one, that is the top left, see the edges of the wire with which it is made are on either side. So if you insert the paper from the top or from the bottom, in both cases, there are chances for tearing the paper because the ends are exposed. Whether you are inserting from the top or from the bottom, in both cases, ends are exposed, ends of wire is exposed, and therefore, there are chances for tearing it. So here it says, don't mutilate your papers with pins, fasteners, etc., but use paper clip, such as those. What has been done here? They simply extended the length of the wire and brought both the ends on one side of the wire. And the other side it is curved. So it is very easy to insert the paper. There is no chance for tearing the paper because both the ends are on the other side, on the opposite side. And what a small change it is, but it made a very big difference. A thing which is invented in around 1894, every country, every person, most of the persons are using it. Every school they are using it, every college they are using it, every office is using it. And for so many years, and it is still such a small inventive step. And what is the inventive step? Bringing the end of the wire, extending the length of the wire, and bringing both the ends together at one place, or at one end. So such a small change, but it made a big difference. And it's a utility increased, and that is why all of us are using it. We will continue to use it for still many more years. Who can apply for a patent? Either by true and first inventor. Whoever has invented it, they can apply for a patent. Or he can assign the right to someone. So sometimes people assign the right to the patent attorney, advocate. They will be applying it on behalf of the inventor. So that can be done both ways, it is permissible. Either alone or jointly. Sometimes you may have an associate with you, and you can jointly make an application. Also be a legal representative of any deceased person. That way also it is possible. And the fees. Here one is for physical filing, and the second one you have for e-filing. Both are permitted. And a number of forms have got to be submitted, 1, 2, 3, and 5. And if it is a natural person, I'll go to the last part. For e-filing, for the natural person, it is 1,600. That is the third column from the right. Top row. 1,600. If it is small entity, a small office, the fees is to be 4,000. If it is a big entity, it is 8,000. Coming to the third column from the left, for the natural person, for physical filing, that means you take a printout and then file it with the patent office, you have to pay 1,760 instead of 1,600. You have to pay 10% more if you are filing physically. And accordingly, the rates are varying. Because for early publication, normally what is done, if you make an application with the patent office, they will keep it in their file. And after about 18 months only, they will publish it for the knowledge of the public. So if someone has copied another person's invention, he has applied, and the other person is the person who basically invented it, he has some proof for that. And the plagiarizer, he is the one who first applied for it. The person who is the real inventor, he applied secondly. So how does he know? So if the first person's application is published for the knowledge of the public, then the second person comes to know that a person has overshot him, and he can file an objection saying that this is my invention and this is the proof for that, and then he can. So it is necessary that any objection about about the granting of patent, if that is to be objected by the public, it is to be published for the information of the public. So it will be published normally after 18 months, but there is a provision for early publication. You want to publish it early, and you can do that. You have to pay a special fees for that, make a special application for that in Form 9, but the fees is more. 2,500 has to be paid. Accordingly, it is changing, and if it is a physical filing, it will be 2,750. And that alone is not enough. If you apply for early publication, they will find it within 1 month of receiving your request for early publication. So you need to wait for only 1 month. And in normal case, if you are not making an application for early publication, it will be published only after 1.5 years. It will be published only after 1.5 years. And then it has got to be examined. The application has got to be examined by the officers in the patent office, for which you have to apply again in form number 18, request for examination. 4,000 is the fee for that. And 4,400 if you are filing it physically. That means 10% increase is the enhancement is there between e-filing and physical filing. And then it has got to be renewed from 3rd year onwards of your application after it is granted. So 3rd to 6th year, 7th to 10th year, there is a fee structure for that. 11 to 15 years, 16 to 20 years. And you have got to apply with the Controller General of Patents, Trademarks. And there are 4 offices for this, one in Calcutta, second one in Chennai, third in New Delhi, and fourth one in Mumbai. As far as Keralites are concerned, we need to apply with the Chennai office because these are zonal offices. So we fall within the southern zone, and therefore we have got to apply with the Chennai office. What is the time of patent? In India, patent is only for 20 years. In India, patent is only for 10 years from the date of filing of patent application. From the date of filing of patent application, it is only for 20 years. Does Indian patent give protection worldwide? Not at all. If you take a patent in India, that is not valid anywhere else outside this country, because it has territorial right. Third paragraph, first one says, offers only territorial right, and hence effective only within Indian territory. The fourth paragraph says, separate patent to be obtained in that country where the applicant requires protection for his invention. So suppose you want to make use of your invention in the United States, and you got to apply there and get a patent in the United States. Otherwise, you go into start manufacturing it, someone is copying it, you cannot file a suit because you haven't taken a patent there. So it has territorial right. If you get a patent in India, it's applicable only within the boundaries of India and not anywhere else. Should application be filed before or after publication of details of invention? This one has to take care of. To be published, filed before publication. I insist, to be filed before publication of the invention. Until then, it should not be disclosed or published. Very often, we see in the paper that someone has invented something. He wants to make people know that he has made such and such an invention. He goes to, or maybe that he goes to an exhibition and start exhibiting his product, his invention there. After that, he is making an application with the patent office. So as on the date of acceptance, as on the date of the filing of the patent with the patent office, on that day, it is not novel because it has already been published in the paper, in a media, or maybe that you have exhibited in an exhibition for the knowledge of the public. Therefore, as on the date of application, as on the date of receiving of your application in the patent office, as on the date, it is not novel. So you have to be extremely careful. This mistake is committed by most people. Before publication, they publish it before applying. So don't publish it. There are certain exemptions to that. I will come to that. Don't exhibit it at an exhibition for the knowledge or for the information of the public. So it should not be published if you are intending to make an application with the patent office. Don't disclose it. But your associate may be there, or say some other persons also may be there. Like you are taking it to a workshop and getting it manufactured or fabricated there. Someone else is also saying, but it's not on a wide scale. Novelty is verified as on the date and time of receipt of application in the patent office. Novelty is verified as on the date and time of receipt of application in IPO. So that's very important. Under certain conditions, there is a grace period of 12 months for filing the application, even after public. I'll come to that. Can any invention be patented after publication? Generally cannot be filed. But what are the exceptions? Allows a grace period of 12 months for filing patent application from the date of its publication in a journal. You have a scientific journal or maybe a journal, you can publish it there. before filing with the patent office. Public display in an exhibition, next part is important, organized by the government. If it is an exhibition organized by the government, you can exhibit it there before applying for a patent. You are permitted to do that. Or disclosure before any learned society. At a conference, you can go and present it, where it is being attended by many researchers and so on. So in such a learned society, it can be presented. But you have to apply within 12 months. That is important. What are the obligations of the patentee? After the grant of patent, okay, you get a patent. It has got to be renewed every year. We have seen earlier the trademark. You have got to renew it after 10 years. Your design after 10 years. So that way you got to renew it. Here, that renewal falls annually. First 2 years, there is no renewal fee. You make an application today, and for the next 2 years, this is free. But from third year onwards, you have got to pay the renewal fee. If the renewal fee is not paid, patent will be seized. You get a patent, you don't apply for the renewal. Naturally, it will cease from the date on which it is. After that, 1 year period or 2 year period, as the case may be. Can the patentee pay renewal fee at a time or has to pay every year? It has to be paid either every year or you have the provision to pay in lump sum also for 3 years, for 5 years, for 10 years and so on. Whether patent can be restored after a cessation. So by some chance you fail to renew your patent. So it can be renewed or it can be restored within 18 months. So if application for restoration filed within 18 months from the date of cessation, then naturally it can be restored. That happens, but as far as possible, try to ensure that you renew it every year, either by paying the renewal fee annually or maybe in a lump sum and so on. Does the patent office keep information of the invention secret? Yes, up to 18 months from the date of filing or priority date, whichever is earlier, unless applied for early publication. So as I said earlier, if you make an application with the patent office, they will keep it as a secret or they will keep it confidentially for 18 months. After 18 months, they will publish it in the journal, saying that we have received an application for such and such an invention, and this is the description for that. So public can come to know of it, whether this is an item having novelty. So someone can raise an objection saying that this is something which is already published in the newspaper even before the date of filing of application, and therefore it cannot be granted patent. So for the information of the public, it is published after 10 months generally. But there is a provision for early publication. As I said earlier, you can make an application for early publication, in which case it will be published within 1 month of receipt of this particular application for early publication. And it will be published in the official journal of the patent office, published every week, and also available in the IPO website. Indian Patent Office website also is available. So you don't have to pay for that. These patent application once filed, examined automatically. It will not be examined automatically. Once they receive it, they will keep it in the file. They won't open it unless you pay the request for examination by paying 4,000 rupees or 4,400 as the case may be. So you have to, one, file an application. If you wish, you can apply for early publication. And second one is mandatory for examination. You have to file an application for examination. Only after that they will examine. Otherwise, it will be there in their repository. So this can be, for examination, can be received from the applicant or maybe from the third party. That also we can do it. When the request for examination can be filed, may be filed within a period of 48 months from the date of priority or date of filing of the application, whichever is earlier. So you are required to file the application for examination within 48 months of filing of the patent application. So that much of time is there. But it is better to apply for it earlier because there is so much delay in the patent office. To avoid the delay, it is better to apply for examination as early as possible. Application for pre-grant opposition to be filed within 6 months from the date of publication of the application or before the grant of patent. Say somebody makes an invention and then he has published it in the newspaper. After that, he has filed the application with the patent office. Now, the thing is published after 18 months or maybe within 1 month from the date of filing of application for examination, not publication. So other parties come to know of it. And one party says that this is something which is which has already come in the newspaper. He is showing the proof for that. So naturally that becomes a drawback for the inventor or the patent applicant because he has already published it before filing the application with the patent. So somebody is making an objection with the patent office saying that this is something which is already published. And the patentee will be given an opportunity to explain his position. But if he is not able to convince the patent office, then he will not get the patent. So be careful not to publish your invention before filing the application with the patent office. Any fee for filing such representation for pre-grant opposition. So this objection is before before granting the patent. There is no fee for, and this can be filed by any person. Time limit for filing post-grant opposition. After granting a patent also somebody can raise an objection. But that is to be done within 12 months from the date of publication of the grant of patent in the official journal of the patent. So you say that this is something which someone else has made and he has copied it. He can make an objection, but it has to be done within 12 months from the date of granting of the patent. This has to be taken care. All these things are available with the patent office. Information is available with the patent office. Is there any fee for filing post-grant opposition? We have seen earlier that for pre-grant opposition there is no fee. But if you are filing it as a post-grant opposition, that means after the granting of the patent, for natural person it is 1,500, and for persons other than natural person, let's say university registrar is making an application, then 6,000 for the registrar in the official capacity. Can one use the words patent pending or patent applied for? Normally used by the patent applicant to their products after filing his application for patent to make the public aware of it. Very often you see on products patent pending or patent applied for. The impression is that that particular product, a patent application is pending with the patent office. Use of these words where no application filed is prohibited under the law. That is illegal. To use the words patent pending or patent applied for without having applied for the patent. So you have to be careful about that. How useful is the marking of product with patent pending or patent applied before the grant of patent? It is very useful. But there is no legal significance for these words unless patent granted. The infringement action can be initiated only after the patent is granted. But you have already given a warning to the public saying that this is an item for which application is pending. So the public has been warned about it. Someone is illegally manufacturing it. But after getting the patent, you can file a suit against that person who has influenced your right, and then the court will consider whether you hold a patent. If you make a case before the granting of patent, your case will not be considered. You are likely to lose the case. Where could one find copy of the patent office journal without purchasing the application publication? It's freely available on patent office site, that is www.ipindia.nic.in. Also available in the technical libraries maintained by the patent office. And the fifth one, so we talked about copyright, we talked about trademark, we talked about design, we talked about patent. So the fifth one is integrated circuit layout design. What is layout design? Layout of transistors and other circuit elements, including lead wires, connecting with elements and expressed in any manner in a semiconductor integrated circuit. This is the definition for layout design. Why to protect? IC layouts are creations of human mind. There is a lot of investment of time and money in the creation, but copying is very cheap. Someone can look at the layout and then easily he can copy it. It's a fertile area with a new circuit design meant every day to get into miniaturization and novel applications. So this is a very fertile area, and therefore you need to protect your rights. Protection is against act of reproducing a layout design, is against the act of reproducing a layout design fully or in parts. You cannot reproduce it in fully or in parts. Importing, this protection is against importing, selling or distributing commercially a protected layout design or IC incorporating. So that is also you got to be careful. Criteria for registration of IC layout. It must be original. It should be distinctive, capable of distinguishing from any other layout design. So these criteria have got to be satisfied. It has to be original, should be distinctive, capable of distinguishing from other layout design. And the term of protection is only for 10 years from the date of filing of an application or registration, or from the date of first commercial exploitation anywhere in the world, whichever is. Next comes the sixth one is geographical indication. GI is a sign used on products that have a specific geographical origin and possess qualities or reputation that are due to that origin. Geographical indications are intended to designate product quality, highlight a brand identity, and preserve cultural traditions. Objectives: customers must not be misled. Marking must not mislead. No dilution, economic prosperity. So these are the objectives for the granting of geographical indications. Customers must not be misled. Marking must not mislead. No dilution, economic prosperity. See here some of the items like Kanchipuram silk, Darjeeling tea, Basmati rice, Kolhapuri chappals, Scotch whiskey, Sheffield steel, and so on. Kanchipuram silk, the silk produced in Kanchipuram has certain quality. If you are making that silk somewhere else, that particular quality will not be incorporated in that. Darjeeling tea, the tea grown in Darjeeling, in that particular environment, it has a special aroma, taste, etc. Certain quality is there. You bring a tea sapling from there and plant it in Munnar and say that this is Darjeeling tea. Of course, the tea the plant brought from Darjeeling, but it is grown in the climatic conditions in Munnar, you cannot claim that it is Darjeeling tea. It has got to be the Darjeeling tea, the tea grown and planted in Darjeeling, grown in planting and harvested in Darjeeling. Then only you can say that it is so. So this is the indication for Darjeeling tea, the Kanchipuram sari, Mysore silk, Coimbatore grinder. You use it for grinding rice or whatever it may be. The granite stone excavated from Coimbatore, certain region, it has a certain quality. It's an abrasion, that means once the stones are grinding against each other, abrading takes place. So once you make the dough out of it, maybe that the amount of that sand or granite powder in it is less. But if it is a granite stone excavated from somewhere else, and it may abrade fast, and the dough may contain a lot of granite sand particles in that. So this one is having a certain quality. What are the famous GIs from spices? Alapi green cardamom, Alapi coir, Aramula kannadi, Navada rice, Palakkad matta rice, and so Vazhakulam pineapple, and so on. Lot of such things are there. There were so many items are there. GI registration, registration of goods, it is 5,000, registration of authorized user is 500, and GI protection is initially for a period of 10 years. It is renewed indefinitely. The last one is trade secret. Coca-Cola, all of you are familiar with this. This is the best kept secret till date. The formula of Coca-Cola, that is the best kept trade secret. What is a trade secret? Some inventions, data, information cannot be protected by any of the available means of IPRs. Such information is held confidential as a trade secret. Say, if you are filing a patent, filing an application for a patent for the Coca-Cola, you have to disclose the formula for it, how it is made, what are the processes involved in it, what are the ingredients. All this have got to be publicized. So others come to know of it. So in such a case, what they do, they don't publish it. They keep it as a secret. And that is why Coca-Cola's formula is not known to anyone even today. Trade secret can be an invention, it can be an idea, survey method, manufacturing process, experiment result, chemical formula, recipe, financial strategy, client database, etc. All these can be protected as a trade secret. Trade secret, don't tell anyone. If it is a secret, don't tell anyone. Information that is not known to outside, that is not known outside of an organization, that provides a competitive advantage. So if the formula of Coca-Cola is known to anyone else, then he can, that person can manufacture it, can produce it. No one is able to produce a drink in the same quality as that of Coca-Cola only because the formula and process is not known to anyone else. Some of the examples are formula for Coca-Cola. It has a trade name Coke, trademark. Decided not to patent, to keep secret forever. They didn't patent it. They patent it, they will have to disclose the formula and the processes. So decided to keep it as a secret. KFC's Kentucky chicken fried chicken secret recipe is not known to, it's known to only 3 executives have access to the recipe. Others are not knowing it. WD-40, which is a lubricant applied in cycles, machines, and so on. It is secret, is the formula is guarded, or its secrets is guarded in a bank vault. Company mixes the formula in only 3 facilities to maintain the secret. Say for making WD-40, imagine that there are 6 ingredients for making it. What the people who are keeping it as I say, what they will do, they have say 3 processing centers. At the first center, they'll mix the first and second ingredients. And then they'll take that product to the second station, where they will add the third and fourth ingredients. So first and second combined at the first station, and then it goes to the second station. So the people in the second station does not know what happened in the first station. So it is a secret. Now they add third and fourth component, and the product from there is transferred to the third center, where they are mixing the 5th ingredient and the 6th ingredient. But they do not know what happened in the second station and in the first mixing station. So that way, the whole thing is a secret. It is known to only a few people. And that is how the secrecy is maintained. When trade secrets are preferred, when invention is not patentable, it may not be a patentable invention. Patent protection is limited to only 20 years, when secret can be kept beyond that period. There is no time limit for it. When cost of patent protection is prohibitive, especially in the United States and Western countries, it is the patent attorneys and the patent officers, they charge very heavily. Huge amount is involved in it. So they don't patent it. When it is difficult to reverse engineer, that is important. Coca-Cola, people have been trying to reverse engineer. They take Coca-Cola, they analyze it and try to reverse engineer, but no one has been successful in that. So it's a product where it is reverse engineered. But if it is something like say a plier, you take it and you know what all things are there, immediately you can do that. So reverse engineering is possible. But in this case, formula and all, reverse engineering is difficult. So in such case, trade secrets are preferred. Famous trade secrets. Kentucky, secret mix of ingredients that KFC, a fast food restaurant chain, uses to produce fried chicken. What that mix of ingredients, no one knows that. Dairy milk, Cadbury's, and so on. These are some of the. So that is the gamut of intellectual property rights. I had left with 7 of them. First one is copyright, second one is trademark, third is design, fourth is patent, fifth is geographical indications, and then trade secret and so on. In between, I think I missed one. So let's see, in some cases, in the case of some of the inventions, multiple protections may be required. By multiple protections, what I mean is, say, attached to a product, there could be a copyright. Attached to a product, there could be a trademark. Attached to a product, there could be a design. Attached to a product, there could be a patent. Attached to a product, there could be a IC. Attached to a product, there could be a geographical indication. And lastly, it may also be having a trade secret. Let's see some of them. Take the case of a writing pen. Take the case of a writing pen. It has it may require a patent because the ink flow mechanism, the ink storage mechanism, all these things would desire that it has to be patented. Secondly, its shape, size of the tips, and so on, that will come under industrial design. Shape of the pen. The first one is the mechanism of the pen, that is patent. Second one, it is the design, shape. Third, copyright. You may have certain engineering drawing associated with that. So engineering drawing, the third one. It has a name, say Parker. It has a name. So it is a trademark. A trade secret, natural dye for color from a plant. They are using a particular type of ink in their pen. That ink is manufactured and the secret, that a formula of that ink is kept as a secret. And then that ink may be produced from a particular type of plant, dye. So that plant is grown in a certain region, so plant variety and geographical indication. So a lot of things are involved in it. It has a patent, it has an industrial design, it is eligible for a trademark, eligible for a trade secret, for a geographical indications and so on. So multiple protections are required. You are going to individually apply for all this. You have to apply for a patent, you have to apply for a design, one has to apply for a copyright, one has to apply for a trademark, and so on. Here, this is a vacuum cleaner. It will have a trademark by the name Megavac. So Megavac is a trademark. And the components and the arrangement of components in that coming under the patent. And then its advertisement is done on the TV, which is eligible for a trademark. And what are the stages involved in the granting a patent or anything? First is filing an application. If it is a patent, you are going to give complete specification. I mean, complete details have to be given. In some cases, it can be done with a provisional specification also, provisional details also, because say it has not been complete, work has not been complete, and in which case you are fearing someone else would copy it. In such a case, with the idea itself, you can file an application, but it will not be granted. Only after filing a complete specification and the complete details that it will be, then request for early publication in the patent office and so on. So that procedure, they will make certain, they will examine it. If there are some objections, they will let you know, and you have to give a clarification. If it is acceptable, patent will be granted, or whatever it is, that will be granted to you. Otherwise, they will let you know what all these things are. And there is now patent attorneys. Attorneys dealing with patents, copyrights, this is a specialized field. Many advocates are now turning their attention to patent filing and so on. They are generally known as patent attorneys. There is a provision in the IIT, especially IIT Kharagpur, where they have a law school. You can study law there, and where specialization can be there in patenting. So it's a technical organization, and at the same time, it's now having management school, arts, law school, and so on. So here you can make an application. Generally, if any one of you is interested in going for that, you can make an application with IIT Kharagpur, LLM. ജനുവരിയിലാണ് അപേക്ഷ ക്ഷണിക്കുന്നത്. എഴുത്ത പരീക്ഷ വഴി തെരഞ്ഞെടുപ്പ്, നിശ്ചിത സീറ്റില്ല, കട്ട് ഓഫ് മാർക്ക് മുകളിലുള്ളവരെ മാത്രം പരിഗണിക്കും. ക്രിമിനൽ ലോ, കോർപ്പറേറ്റ് ലോ തുടങ്ങിയ സ്പെഷ്യലൈസേഷനുകളുണ്ട്. ട്രിവൽസിലെ LLB ഇവിടെയുണ്ട്. So if any one of you are interested, you can make an application based on this. So look for the advertisement. And there is a world body governing intellectual property, which is known as World Intellectual Property Organization, WIPO. It has its headquarters at Geneva, in Switzerland. And this is their site. So to sum up, know your rights. That is the purpose of this webinar. Know your rights. I have tried to convey some information on intellectual property rights as it is applicable in India. So know your rights. You can learn more from the Indian Patent Office by going to the site and finding it out. And how many items are there? Copyright, trademark, design, patent, layout design of IC, geographical indication, and trademark. You can change the world. How? You can change the world. Every one of you can do that. See this invention which I showed in the beginning, a coconut binding invention made by an illiterate farmer. I underline the word illiterate farmer. If a person, I would say this is one of the best equipment invented and patented in India. It has come from a Kerala farmer in Kannur. There's a place called Chemberi. He is from Chemberi of Kannur. He invented it and then he patented it. So if an illiterate farmer could develop such a beautiful and awesome, wonderful device, why not you? He changed the world. This farmer, through his invention and patenting, he changed the world. If he could do it, why not you? That is my appeal to you. You can change the world. Try for that. As I said, this is that illiterate farmer who created such a wonderful invention. So I would say again, I would stress, you can change the world. Just like Mr. Joseph changed it. Change the world for the better, and I wish you all the best for the same. You can take note of if anyone has got any doubts or would like to get some clarifications, get more information on it, you are welcome. And this is my address, phone numbers, email ID, and so on. The first one is the WhatsApp number. So you can, those are interested, can take note of it, and then you can communicate with me. I will be more than willing to help you in whatever way possible by me. So thank you very much for your patient listening. And I would again express my gratitude to the St. George College, Arivitra, its management, its administration, and also Mr. Professor Mithun for having invited me and given me an opportunity to interact with you on this particular topic. Thank you very much. If there are questions, you are welcome.
Okay, thank you, sir. We are at the last part of this webinar. It was really interesting and encouraging, especially for young aspiring inventors and entrepreneurs. Now the platform is open for discussion and interaction. You can post your questions in the chat box. If you have any questions or queries, you can post your questions in this chat box. Sir, there is one question. In this world of open source software and internet, whether IPR and patents are creating hindrance for freedom?
I think the question, it's not a very clear, audible.
Sir, in this world of open source software and internet, whether these IPR and patents are creating hindrance for freedom?
Mostly people are interested, but still you can do patent search and then find out. You can go to the Google and so on and find out whether something similar to that is already existing or not. Because in the case of every intellectual property, you need to establish the novelty of it, whether someone is having it. So you can search the sites, different sites, and then find out whether something similar to that is existing. So what improvement is there which you have made, which is eligible for your granting a patent, copyright, etc.
Okay, sir. The question is whether there are a lot of open source software and internet. So this filing patents and by filing IPR, whether it creates any hindrance, means any objection for freedom.
I don't think.
Okay, sir. Sir,
But it has to be protected well, because as far as India is concerned, your software doesn't come under patents. It is coming under copyright.
okay.
But if your software is having a hardware associated with that, in that particular case, it will be eligible for patent, but not software as such.
Okay. Thank you, sir.
Software one has to go for copyright.
Okay. Thank you, sir. Is there any nodal office or any service society for helping illiterate people for filing patents?
Yeah, certainly our KSCST, Kerala State Council for Science, Technology and Environment, KSCST, they are helping it. Even students also they are helping. You can file an application with the KSCST.
Okay.
They will make a patent search.
Okay.
Because the grassroots level people may not be familiar with the use of internet and so on. So what they can do is they can make an application with the KSCST. They will do patent search and let you know whether it will be eligible for patent, and then they will make associate you with the patent attorneys, and they have a provision to pay the fees also.
Okay.
That's for grassroots level people.
Okay. Thank you, sir. Now we are at the end of this webinar. For the last more than 1.5 hours, we have been listening Dr. Jippu Jacob, sir. Sir, it was really informative, and starting from the basics, sir has explained all fields under IPR. On behalf of St.George College, Arivitra, I would like to extend our sincere thanks to you, sir, for your informative talk. I would like to thank our beloved manager, Reverend Father Dr. Agustin Balakaparambil, our respected principal Dr. Georgis Megadan, respected Bursar and course coordinator Reverend Father George Bullialain, and respected IQAC coordinator Dr. Jilu Anijon for their unbounded support. I would like to extend our sincere thanks to the fellow participants for the success of this program. I would like to thank Professor Midun John for arranging a webinar on very relevant topic, and also for inviting the right person for this webinar. I would like to thank all the fellow participants. Thank you. The meeting has ended. Thank you very much.
Thank you.